Come on up here. What a sad commentary that I have to have the mother of a 25-year-old come up here. Your name, ma'am?
Miss Patricia, last name's Monet.
I don't know what to do with your son here.
I don't know what to do with him either, Your Honor. He's destroying his life.
When's the last time you worked?
About 2 weeks ago.
Where?
The Roofness Home Improvement Company that I usually work for.
Sean Cardinal, Sean Nicholas Cardinal, file number 25G827779A and B.
Good morning, Judge. Mr. Cardinal. Yes, Mr. Cardinal, can you remember the record?
Charles.
Does he stand mute? Wait formal reading?
Yeah.
Now he's going to plead guilty to count 1, property maintenance, with count 2 to be dismissed, maintaining a rodent habitat. Can you call in Gibraltar City Attorney, please? That is a misdemeanor, sir, punishable by up to 500 fines, 90 days jail, costs for all those. Do you understand that?
Yes, sir.
And did you sign, read, and understand an advice of rights form here this morning?
Yes, I did.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a trial. Do you understand? I always do that, you know. All right. So, all right. Okay. You understand everything?
Yeah.
You want to plead guilty
What they're willing to work with, so that's what I'll
to the charge, property maintenance violation, maintaining a rodent habitat. How do you plead?
do.
Do you reside at and own the property at 14810 Williams Court in the city of Gibraltar, County of Wayne? And did you do so on August the 5th of 25? What makes you guilty of this offense?
I think I'm not guilty. You're on probably not.
Mr. Bologna?
It's your hand is the way it's just control.
That's why you're pleading guilty to something if you don't think you did anything wrong. Can you tell me the state of this, please, Mr. Bologna? Do I have to go look at the property? I'll look at the property if I need to.
What's the you do? There's still the debris pile in the backyard.
We have debris pile in the backyard?
It's there's some wood trimmings from his yard. There's also some logs that he was drying out because there's in the fireplace. So he was getting them prepped. He's a long haul truck driver, Judge. So he's not home
Yeah, I know, but he's going to do it, and he's going to do it quick because it says numerous issues for 2 years over property maintenance. Ignored request in July 23 letter.
I did discuss proper maintenance storage with Mr.
Do you think you did anything wrong? If you don't, let's go to trial on both counts. You can do that.
Your Honor,
I just listen to my question.
I don't think I did anything wrong.
Didn't you want to go to trial on both charges?
I don't want to pay to go to trial.
You're not with this United States of America. We don't live in North Korea. You don't have to pay anything to go to trial. If you don't think you did anything wrong, by all means, don't come up here and plead guilty. This is the United States. You don't pay to go to trial. Where do we pay to go to trial at in this country? Pardon?
Yeah.
Hang on a second. Now, what will I charge an attorney fees? Shame on you.
Not I apologize. It was the cost of an attorney to represent an active trial judge.
I know, but I don't charge hardly anything in attorney fees. If he can afford his own lawyer, he has to go get his lawyer after today. He has to hire his own. If he can't afford his own lawyer, I charge a minimal amount. How much do you make in your employment?
Your Honor, all my financial responsibilities taken care of. I take home $100.
How much do you make?
I make $25 an hour. I'm pulling a little over $800.
Do you work overtime?
No, there's no.
So you work 40 hours? All right, so that's $1,000, right? If you make 25, 40 times 25 was $1,000, right?
It's roughly 300.
I know. We all pay taxes. These guys pay taxes even. Listen, I don't want you to go and do anything you don't want to do. If you don't think you did anything wrong, don't plead guilty.
I personally,
Sir, then don't plead guilty. Why are you coming up here and pleading guilty? What do you want to do? How about I adjourn this and you guys can all think about it some more? Maybe they can go.
Maybe we can resolve it today without having.
Yeah, I mean, maybe they can go get some pictures. This is pretty easy. I can go out there and look. I mean, we could go out there and look, and I'll take a look today, not today because it's not a trial date, but they can get pictures of the situation, or they can,
Your Honor, may I make a suggestion.
sure.
I like the thought of the adjournment that you recommended. Maybe by the time it's set, everything will be clear, and then we should take it.
Well, he doesn't think he did anything wrong. It sounds like he thinks he can leave it there. To me,
That's not the case, Your Honor.
Hey, listen. Just let me talk to the lawyers a sec. I mean, either you've got a property maintenance issue or you don't. I'm not trying to quarrel with you. You just said you don't think you're guilty. If you don't think you're guilty, why would you move something if you think you're not guilty and you're not creating a property hazard? I mean, $100 personal bond. I'll go ahead and adjourn it. If you guys figure it out and you want to stick around and do it again, that's fine. A free trial again, you can send it in to me. We'll adjourn this 2 weeks. Lisa, what do you have for me?
September 11th at 9:30.
September 11th at 9:30. So you can go down the hall. You can get your notice. I doubt you're going to qualify for a court-appointed lawyer. I mean, you're making $52,000. You're not indigent. We have to give somebody a lawyer for arraignment and pretrial. So if you guys work it out, great. Come on back. If you don't, we'll come back for pretrial. If it doesn't resolve, then I'll just go ahead and set it for trial. It'll be your desire, whether you want jury or bench. Okay.
Okay.
$100 personal bond. You cannot leave the state without consent or violate a law. Sir, are you listening to me?
You gotta come back.
I'm sorry.
You cannot leave the state without consent of the court. You cannot violate a law. You must appear in court as directed. Okay? All right. Good luck.
Thanks, Your Honor.
Ross. People against Devontae Dewan Ross, 25T645-998 A and B. And could I have Stacy Gee seated at the table here, my right, your left, sir, your name? Where you been?
Over. I saw it last day.
Why weren't you here August 14th?
I got the letter at a later time.
We gave you the notice when you were here July 31. You got to show up, son. You do this again, bring a lot of money with you because I'm going to set a high bond. You'll be sitting in jail. Do we understand one another? Yes?
Yes.
Is Trenton here today, Lisa?
Yeah. Do you need prosecutor?
No, I need him to go pre-try the case. You waived your right to a lawyer previously. You still wish to do that? I can't hear you.
Yes.
Go talk to the prosecutor. Don't miss your court dates again. You understand?
Yes.
Either way, you're coming back in front of me. Okay? So you go see what you can work out with the city attorney. Ross. Devontae Dewan Ross, 25T645-998 A and B. Okay, Mr. Ross, come on up here. Tell me your name.
Maybe I'll tell you once.
So you met with the prosecutor and you were going to plead guilty to the added count of no valid operator's license on person. You're also going to plead responsible to expired plate, as I understand it. And then they're going to dismiss the driving on a suspended. True?
Yes.
Is that what you want to do?
Yes.
No valid ops on person is 0 points. It is the maximum penalties provided by law are up to $100 fines, 90 days jail costs, or all those. Those are just the maximums. Do you understand that?
Yes.
I can't hear you.
Yes. Yes.
Did you sign the advice of rights?
Yes.
Did you read it? Understand it?
Yes.
If you plead guilty, you'll be giving up all those rights and we are not going to have a trial. Do you understand that?
Yes.
You still wish to waive your right to a lawyer? To the charge, no valid operator's license on person, how do you prove it?
Yes, sir.
I'm sorry?
Yes, sir.
How do you plead to no valid operator's license on person?
Guilty.
Were you operating a motor vehicle in the city of Trenton, county of Wayne on Fort near Sibley at 9:13 in the morning on July the 8th of 25?
Yeah.
Did you have a valid license with you on your person? Are you on probation or parole right now?
No.
Anybody force you to plead guilty?
No.
To the charge expired plate, how do you wish to plead? Responsible or not responsible?
Responsible.
I'll accept that plea, accept the no ops plea, dismiss the suspend. I find the plea has been made voluntarily and understandingly. You're still suspended, right?
Yeah.
Why aren't you taking care of business here? Do you work?
Yes, a lot.
Where? Where?
7 Up.
7-Up?
That's,
What do you do there?
I make the orders by the choice.
Okay, good. All right, you got to get your license back in order here. You're still suspended.
Is it possible to get on the plan or the play?
For the plate? What do you mean?
Right.
Yeah, I'll do that, but let's figure out how much I'm going to charge you first. Is there anything you'd like to tell me before I sentence you? 100 fine, 70 costs, 75 victims' right fee, $50 justice assessment, $295 or 60 days on the no ops, $135 on the expired plate. Your total here is $430. Do you have some of that to pay?
A little bit.
How much do you have?
Like 75.
All right, you pay 75 now on the expired plate. That leaves you with a balance on that of 60. When can you pay that? You pay weekly or not?
Weekly, next week.
You pay the balance on that. Can you do that? And I'm asking you that. Can you pay the balance on that by September the 8th?
Yes.
And then on the other case, I'll just let you pay. Can you pay 50 per week?
Yes.
50 per week beginning September 15th. Okay.
Yes.
If you need more time, no problem. Call the court. We'll go on Zoom, or you can come in here on or before your due date. I'll be glad to give the extensions. Just please don't ignore them. Okay. I wish you well. So next time, show up in court, though, will you please?
Okay.
And good luck. Masuch. Jacob Kelly Masuch, 23T639985A, 23T640501. Your name?
Is that your guys?
Where you been? I feel like I need a recorder here. Where you been? Why haven't you been here? Like just one that I'm gonna use every two after this stations. I thought, where you been? This is 2023 case.
Due to the date, I had moved addresses, or I didn't have they sent it to my husband's address, and I'm really
Come on. You got a ticket handed to you, right?
Yes, sir.
Did you call the court and come in? No.
I didn't know nothing about
Or
it.
did it say, that doesn't say on here, parents' date on or before 10 days?
The date, I never received it. After the incident happened, I never received it.
He gave you the ticket. This is a drive while suspended. The police
I
are.
thought you were talking. Yeah. At the date, at that time, I didn't know I had it. It's the driving hours.
Did he hand you the ticket?
Yes, sir.
Did you call the court?
I'm sorry.
Okay. And then you got arrested and now you got a bond of $300, right? That's the only reason you're here. You got arrested. You have the right to a lawyer on this suspend charge. You also have an assault or assault and battery charge from 2023. Did you forget about that one too?
That was the one I didn't have knowledge on. I thought that's what we were talking about.
All right. I'm going to give you a lawyer. We have two cases with suspend and assault or assault and battery. You go talk to the lawyer. Either way, you come back in front of me with the lawyer, okay? I'll be sitting here waiting. Thank you. File number 23T639985A, 23T640501.
Very good morning, Derwin Haynes, Jacob Message.
Your name? Let's talk about the suspend first. Does he stand mute? Wait formal reading on that.
Yes.
I'll enter a not guilty plea. He's going to have to fill out a petition for a court-appointed lawyer.
I think you did.
Okay, good enough. And then what are we doing on the assault and battery?
We wait for more ready to meet on that as well.
And we're gonna adjourn that as well.
Yes.
All right. So I'm gonna go ahead and enter a not guilty pleas for you on both of these terms, sir. You cannot. Here's your bond conditions. You cannot leave the state without the consent of the court. You cannot violate a law or ordinance. You must appear in court as directed. No contact on the assault and battery with the victim. You're no contact with prosecution witnesses. You're not to enter the property address at 3350 Edison in the city of Trenton. You're not to leave the state without the consent of the court. You're not to violate a law. You must appear in court as directed. You're not to possess firearms, no dangerous weapons. Do you understand that? If you have firearms, you have to surrender them to the Trenton Police Department. So those are your bond conditions. You posted bonds on both because we had warrants out for your arrest. $300 bonds are continued on each case. Do you understand all the bond conditions?
Yeah, Your Honor.
Just regarding the adjourn date, he's got an appeal pending with the Secretary of State regarding his license. Should get a result back in 3 to 4 weeks. So we're hoping for a date 5 to 6 weeks out.
I'll give you 4. We'll see where we are. September what, Lisa? 5th, 25th?
25th at 8:45.
At 8:45. Okay? What now? You haven't been here in 2 years. It's not on my Christmas card list. He doesn't show where you. I'm just saying.
His children, he's got 3 children, ages 6, 5, and 2. They live at the house where he's not permitted to go. Could the court direct some kind of a third party exchange?
See now, this is the problem. I don't know who they just take. You know,
If not, I can.
hang on. Call him Trent. I mean, they didn't really give me any information. I don't even know who the victim is. I've been talking about this since 1998. Hitting the victim. I don't even know who the victim is. I don't know. Can you tell me?
Sure.
Was it allegedly an ex-wife or girlfriend or something?
So, this would be the stepfather-in-law, if you will. The
The
mother,
children's stepfather-in-law.
no, so the mother of the children has moved back home with her parents. The stepfather's the alleged victim. So
I see.
and they have joint custody.
Well,
If not, I was dropped off at my address. I don't have to go nowhere here. It was just a question.
was your ex-wife or the mother of the children, was she present at the time of this?
When she got charged as well in a separate assault with her mother.
All right, let me just figure something out here. You don't really need to have. How have you been exchanging the children?
She's been bringing them to me, or I've been meeting her.
Mr. Bologna, your name?
Yeah, good morning, yeah.
So I'll bring this up again. It'd be helpful if they tell me who the victim is, what kind of an assault it was on these tickets.
Okay.
So,
No remarks. Yeah.
okay, so Adam Forstel was on the complaint. That's the stepfather-in-law, counsel.
Yes.
So there's an issue as to exchanging the exchanging of children, Mr. Bologna. I'm ordering him not to go back to 335. She's apparently separately charged. His ex-wife, right?
My
Ex-girlfriend, who's the mother of the children. She's been charged in an assault, same incident. I want him to be able to see the children. I'm going to say no contact with prosecution witnesses except to affect visitation. So you can talk, unless you're going to tell me a reason why I shouldn't do this, Mr. Bologna. I'm going to let him have contact with the ex-girlfriend to affect visitation with the minor children, but I don't want you going to 3250 Edison. You guys figure out how you're going to exchange the children. Do you understand that? And I'm giving you those bonds, and you will go down the hall. If you need a court appointed, you're going to have to fill it out. I think you said he did, right? Where does he work?
I work with my uncle.
Yeah, that doesn't tell me anything.
I cut grass.
Okay, so you make $500 a week. All right, I'll go ahead and appoint you a lawyer. 26,000. All right, good enough. Go down the hall, get your notices, and we're all set. Anything else?
Okay.
Thanks. Have a good day. It's Nicholas J. Horn, 25T704225.
Good morning, Your Honor. Kevin Engel appearing on behalf of Mr. Horn with my left in your forewings.
Did you file an appearance?
I have one. I brought one with me. I have two actually, one for the court and then one I could file.
Yeah, hand him up if you would, please. Nice to have you here.
Thank you, Judge.
Have I had the pleasure before?
I've never been here before. I'm out in Livingston County.
Okay.
Took the ride down here. I actually like going to courts that I'd have visited. I'm supposed to these once.
I got it. Does he have your name, sir? Does he have a medical marijuana card now?
He does not, Your Honor. So, oh, you do? Okay, so Mr. Horn does have one. I have a letter. I understand the Marijuana Act. He does have a bona fide relationship with his doctor. I do have a letter from his doctor that recommends.
I'm not going to have a problem with it if he has a. Here's what I'm going to do. So it says request for medical marijuana approval due to chronic pain in right knee caused by torn meniscus, and I do not want to be a drug addict. Psychiatrist and therapist recommended. Here's what I'm going to do. Give me 1 second. Today's what, the 28th or 9th? 28th. All right. I'll just indicate defendant is not to be violated if he's positive for THC. So long as he possesses a valid medical marijuana card, okay?
Thank you, sir.
So you're going to have to show that to probation, sir. Okay? Do you have it with you?
Yes.
All right. So you can go over there. Who's your probation officer?
Mr. Cino.
All right. So tell him I'm going to send him over to show her the medical marijuana card, okay? What's Emily's number? 253. Listen, I've got a gentleman in front of me who has valid medical marijuana card. I'm going to allow him to use it so long as he possesses a valid medical marijuana card, or at least yes. Do you need to see him for any reason? Okay, so I'm going to see. That's exactly what I wanted. I'm going to send him and his lawyer will show you the card. Okay, he's got it. Thank you. Bye. You can go right over. I filled out the order. They'll give you a copy of the order, and you present that to Ms. Tessino. Okay. Thanks a lot. All right, people against all in dumpster. I'm going to call one at a time. 25T645-975. That's A and B, and then I have all in dumpster 24T643-942, and then I have 24B146374B and A. All right. Your name?
Nicholas.
What is your position?
Or
Is this a corporation?
LLC.
You just. You don't want to go hire a lawyer? I just. Yeah, I'm reluctant to take these without a lawyer. I'm going to do it. You got to show up. Why didn't you show up on this case?
I never received them. At the time, I guess there was a couple of acquisitions for the company.
Acquisition.
Yeah.
Big words he's using out here. Acquisitions, mergers and acquisitions, and what else?
Public school.
What's that?
It's a lot for public school, I understand.
All right, let's talk about 942. You're going to plead to defective equipment, right?
Yep.
You're authorized to enter that plea on behalf of the company?
Yeah.
To that charge, responsible or not responsible?
Well, that's true.
Please, are you going to plead responsible to having a commercial vehicle with defective equipment?
Yes.
To that charge, responsible or not responsible?
Responsible.
All right, I'll accept the plea. 235 is the total on 25T645-975. The serious safety defect charge, file A, will be dismissed if you plead, according to the prosecutor here, on file B, which is defective equipment. Do you understand that?
Yes,
To the charge defective equipment, responsible or not responsible?
not responsible.
To defective equipment,
Well, the first one I was responsible for, and the other one he dropped.
he's dropping the serious safety defect.
Okay, then yes, responsible.
All right. Want to make sure you understand.
Yeah.
You got a serious safety defect and defective equipment. You're going to plead responsible to defective equipment?
Yes,
To that charge, responsible or not responsible?
responsible.
That plea is accepted. Fines and costs on that are $235. File A, a serious safety defect, is dismissed on motion of the plaintiff. Then you got 2 contempt charges here. I can't believe you weren't showing up here.
Well, like I said, I didn't not receive.
What do you mean? The post office is not there, they're not.
Yeah, well, also went through some.
Let's talk about this. You owe $318 on each charge. I can go through and formally arraign you. Do you have the $636 to pay these 2?
No.
How much do you have today?
Like I said, how much are I pay loan? Like I said, I don't even know what the charges were for.
And no annual inspection.
Okay.
Let me see here. All right, something happened here, Lisa. You're gonna have to help me out. I got a citation in this file 643. Oh, that's the other one. I think they give me 1 second here. He was show caused on which cases, Lisa? It looks like somehow these were interposed.
The Brownstown cases and 1 Trenton case.
So let's talk about the Brownstown B146-374B. You're going to have to look at these tickets. Somehow they got in the wrong files. Probably the prosecutor did that accidentally. So I'm going to go ahead and indicate on the annual inspection 24B146-374B. You're going to pay that today, right?
Well, I go back to the office and get the place. I can call it in.
All right, on 374B, the total's 318. I'll cut it to 300. You pay that by 11 a.m. Okay? Do you understand that? Then on 374A, you owe 318. When can you pay that?
I mean, I just have to card and stuff. Like I said,
I thought you said you could only pay one a week.
I have to card. I don't know how much money's in the account because I took a partnership with the company. I'm not definitely with my answer anymore. I don't have the answer for it now. So give me to get one. Everything.
You pay $300 on 374A. Because I'm having them pay 374B by 11 a.m. You pay 374A by September 30, okay? You pay these other cases, I'm going to give him until September 30. All right, now listen to me very carefully. If you don't have the money, no problem. Just call the court. We'll go on Zoom. I'll give you an excuse.
So I think it's scared everything. Today.
You're going to pay $300 today. You can take all the rest of these by September 30. She'll give you a printout down the hall. Okay? Do you understand?
Yes.
All right. Do you have any questions? Again, if you need more time, I don't have a problem, but don't ignore me. Okay? Good luck. Jacobson. Jeffrey George Jacobson, file 24F242782. Mr. Jacobson, how are you? Your name? I placed you on probation November 14 of 24 for 18 months. You had one prior technical violation. Probation thinks you violated again. They think that you failed to refrain from consuming alcohol or drug. Excuse me. Testing positive for marijuana on a chemical test of August 1. of 25. If you plead guilty or if you're found guilty, this would be a second technical violation. You could get 10 days jail. Do you understand that? Did you sign the advice of rights?
Yes.
Did you read it? Understand it?
Yes.
If you plead guilty, you'll be giving up all those rights on the advice of rights, and there will not be a hearing or a trial. Do you understand that?
Yes.
All right. You have the right to a lawyer. If you want one, I'll give you one. You waive your right to a lawyer? All right. To the charge that you failed to refrain from consuming alcohol or marijuana, testing positive on a chemical test on August 125. How do you plead? Did you consume marijuana, say, within the week before that?
THC supplements for sleeping. I know.
Hang on a second. Did you consume marijuana? I didn't understand what you said.
THC supplements?
Yeah.
Yeah. At the evening time, sometimes I occasionally use that to help me sleep.
But you know you can't do that.
More or less.
Why'd you do it then?
Mistake on my end. I'm gonna refrain from doing that one.
Anybody force you to plead guilty?
No.
All right, I'm gonna accept your plea. I found it to be an accurate plea. Let me get probation over here. If you'll have a seat at the table there, right behind you. We're gonna call in Jessica, and I'll sentence you momentarily.
Sorry.
All right. Your name, Ms. O'Donnell?
Just what I'll have to.
Sir, your name?
Jumping.
You still wish to waive your right to a lawyer?
Yes.
He pled guilty. What do you have to say, sir? Anything you'd like to tell me? You can't do this.
Oh yeah, it was my mistake. I just one of my fault. I don't smoke. I don't regularly or do anything like that. I don't smoke at all, actually. It's something that helps me sleep at night.
Well, have you been doing this before? You can't do this.
I understand.
What do you have to say?
He's in compliant otherwise, Your Honor. Actually, on August 14th, I was going to apply him for early discharge. We didn't have this positive test. He's completed everything. Court finds his costs are paid full. 4 hours of community service. That's completed. Days in the sober rolling. 3 days in the court work program. He's completed outpatient substance abuse treatment. I mean, he was going to be eligible for early release, but now he's pushing that back at least 90 days now due to this violation.
Can I see the screening report?
Yes.
Where do you work?
I work for family company. My father wants a whole embroidery and exchange company business.
The underlying charge was OWI. Gosh, you had a 302. Probation is supposed to end in what, May of 26, right?
Correct.
What's the discharge date scheduled?
May 14th of 2026. Judge, and he did have a previous violation back in February for marijuana.
How often do I have him testing now?
Right now, he's only on monthly testing, Your Honor.
On an extent, is there anything else you'd like to say, sir?
Yeah, I apologize. It was a mistake on my end. I was correct that going forward. Maybe for helping me sleep. But yeah, it was kind of silly on my part.
All right. Probation's extended for 2 months until July 14th of 26. Should pay additional costs of 100, additional probation fees of 40. You're to serve 1 day on the court work program, pay $35 to that, and you're to test bi-weekly for the duration of probation. Okay, so we'll schedule you 1 day on court work. You owe the court $175. Can you pay that today or do you need time?
I can say that today.
All right, that's what I'll do. You're all set. You'll meet with Ms. O'Donnell. Thank you.
Thank you.
Crystal Diamond Davis. I need, they were calling over to Gibraltar there. Mr. Bologna was. I don't know what happened on that. He was calling over because I forgot to have them notify the victim. That was my fault. Victim has the right to speak. It was very much my fault. So my apologies to you, man.
He just, the attorney that you told to call, he said he called him and they didn't
You welcome calling it.
All right, is that Mr. Bologna? Yeah, call him Mr. Bologna, please, again. Why don't you have a seat right there, please? Quentin Antoine Clanton. 25G306-486. How you doing, Mr. Clanton? Not too bad. Your name? You should have been a lawyer. You got him to dismiss this, right? You can make sure how old's your son or daughter?
14.
You can make sure they go to school? You graduated, right? We want to make sure your son, it's your son, right? Daughter. We want to make sure she graduates, right? We always want our kids to do better than us, right? My kids are doing a lot better than me. At any rate, I'm going to dismiss your case on motion of prosecutor. Please make sure that you send that child to school so that child can make a living. Okay? Best of luck. Thank you. All right. Crystal Diamond Davis, 25G306-520. Counsel, your appearance.
And we're going about city, scroll.
Ms. Gaith,
Good morning, if you have and get it, and that's Ms. Davis.
your name, ma'am? Did you get a chance to talk to the store?
I did, Your Honor, and all the stolen items were recovered.
And they don't have, and who was the owner that you spoke to?
Oh, I forgot the name of the gentleman.
That's all right, but he was the owner
Correct.
and he doesn't need to make or doesn't wish to make a statement.
No, everything was recovered. There's no restitution.
Okay. Thank you very much. That's what I was more, it was the restitution, but also the fact that I didn't have him notified. So
Not an issue.
thank you.
So, thanks, Your Honor.
All right. So your client pled guilty to retail fraud under 771.1.
Correct.
And, geez, I didn't order a pre-sentence report.
No.
But, ma'am, well, first of all, what would you like to say?
Just, Ms. Davis is 29 years old. She is a single mother of 3 minor children, 4, 7, and 11. They all live with her. She's the sole caretaker for those children, Judge. She works full-time at EMS in Toledo. She resides in Toledo, Judge. And it's an auto parts manufacturer. She works on the assembly line. Judge, she doesn't have significant criminal record. I spoke to her about the events that occurred when she was here back in June of this year. She is remorseful and she does regret her actions. And she assured me that it will not happen again, Judge. You know, she understands that she's got 3 minor children.
She's got another case in circuit court, right?
That case has been resolved, Judge. They're waiting to be sentenced on that case.
Gosh, you guys, I can't believe you were doing this, the 3 of you. I'm just being honest with you. So they were going around, they went to Brownstown, it looks like. And then they were on this case, it's Shore Liquor, right?
Yeah.
Where do you work at? He told me, but I can't remember what he said.
DMS is a factory, auto factory.
How much do you make there?
$15 an hour.
Are you married? You have children.
Yes. About 3 months.
So where were the daughters while you guys were going around and acting like thieves? I'm serious. I want to know that. Where were you?
They were with my mom. So
Because you guys had a concerted effort here. You know that? Concerted effort. I mean, this was, you guys planned this out.
Been here. Thank you.
This was worse, in my view. Anything else, counsel?
Nothing else from, I know Ms. Davis wanted to address the court, Judge.
Go ahead.
Audition for taking accountability and responsibility. I knew I was wrong. And I just wanna, try to put this behind me and do the best I can for me and my kids.
Well, that's good. You guys are in there stealing alcohol. This was planned out. This is pretty obvious to anybody who read this. You guys didn't on a whim or on an impulse decide to start putting a pack of gum in your pants, right? 6 months, 771.1. You cannot leave the state without the consent of the court or violate a law. If you change your address, your place of employment or home telephone number, you must notify probation. You have to report as directed. I'll say you can leave the state, though, to go to Ohio since you reside there, okay? But otherwise, if you're leaving to go anywhere other than Ohio, you have to call the court. I'm sorry, you have to seek permission. You're not to enter 29104 North Gibraltar Road in Gibraltar. You're not to enter that property. Do you understand that?
Yes.
So I don't want you guys going near there. You understand that?
Yes, I do.
I'm going to order that you attend the economic crime program.
Yeah.
3 days community service. This was worse than most. October 28th, you have to have that done by. 100 fines, 75 costs, 75 victims' rights fee, $50 justice assessment, 300 probation fees are 120. Your total's 420. You pay that. You do your community service. Do your economic crime program. Stay out of trouble. Stay out of that store. Comply with all other terms. I'll be glad to dismiss this on motion of the prosecutor at the review hearing date, which we're going to give you right now. You have 21 days to appeal and you have 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand that?
Yes.
Lisa, I'd like, John. I'm not happy. Can you pay all that today?
She doesn't have.
How much do you have today? How much can you pay weekly?
75 a week.
I'll make it 50. We'll start it beginning on September the 19th. If you don't have the money at any point, no worries. Call the court. We'll go on Zoom or come talk to me. I'll give you an extension. Okay.
Yes.
What do you have for me as a prosecutorial review date, Lisa?
February 19th at 9 o'clock.
February 19 and 26 at 9 a.m. Why are you smiling?
So that's my daughter's birthday.
That's your birthday?
That's my daughter.
Your daughter's. Don't bring her to court with you. We don't want her to see this place. Good luck. Dylan Lake Neck. 242-643-449 A and B. And also 23F240232. I'm gonna need Jesus Wiles in here. Your name, sir? Counsel? All right, so Mr. Minnick is in here on multiple violations. He's got 13 of them. He has no prior technical violations. I set a bond on him of 7,500, 10% on August 25th. How is he going to proceed on all of these? Let's start with the misdemeanor charge of the operating while impaired from July of 23. How is he going to proceed on all of these?
They're just standing in the hearing.
Well, he already did that. We're gonna have a hearing today, right?
On that, I wasn't aware, Judge, that we're having a hearing right for that.
Well, he stood mute and waived reading on August 25th. I set a bond. He's got multiple charges. Failure to attend the probation visit. September 12 of 23. Failure to attend the court work program. August 12 of 23. Failure to attend, provide proof of completing victim's impact. Failure to pay fines and costs. Balance owing $12.85. Failure to refrain from violating a law. Being convicted of disturbed the peace in August of 23. Failure to refrain from consuming alcohol or drugs. Testing positive on July 31 of 23 for heroin, fentanyl, THC, opiates, and meth. Failure to submit to weekly testing as ordered. Count 6, August 11 of 23. Count 7, August 16 of 23. Count 8, August 22 of 23. Count 9, August 29 of 23. Count 10, September 6 of 23. And then failure to submit to weekly testing as ordered on September 15 of 23. Failure to provide verification of attending NA 3 times a week until an IOP. And failure to provide proof of attending and completing intensive outpatient treatment. So those are the charges.
Judge, if the court would recall, when I was in here earlier, and when was having a breakdown outside, the court did indicate that they would allow you during.
Why?
I think that was communicated to Mr. Murdoch, and that was, I believe, the reason that he came back. He's gonna ask the court to adjourn this so that if the court does decide that he's gonna go out and serve some time, he's gotta make arrangements, Judge, for he's got some young children, and a girlfriend that live with him.
How old are you?
25. I'm trying to.
How old are you?
25. I'm
How old are you?
25, sir, and I'm trying to.
How old are you?
Like if no,
No, you're not acting anywhere close to it.
I just trying.
It's time to grow
I
up.
was-
Stop. If you're going to act like a criminal, at least take it like a man. Do you understand what I'm saying to you?
Yeah.
Okay. You have 13 counts. You haven't been here in 2 years. I mean, you're going to have to search hard and far and wide and long and probably, I don't know where you'd go in the United States to find somebody who's going to be sympathetic to you, son. You don't do this. You don't do this. So I don't really want to hear it. We're going with the hearing today, or you're going to plead today, whichever your choice is. Do not walk out of this building. Do we understand one another? It's that simple. No wonder he's worried about going to jail. I didn't even stop.
You know what I'm saying?
Stop.
You know, you're good.
No, no,
I'm talking to your lawyer right now.
I apologize. I apologize.
Yes.
I get it. It happens. The meth, the fentanyl, the heroin, all the opiates. The chance of surviving that and being happy, I'd say, are the shot chance of some ball player tonight hitting a fastball over the center field fence 729 feet. Now, I'm not going to play games with him. And I resent you going out and acting like a child and screaming. Okay? Is this his mother?
Yes.
Yes, Your Honor. Mother.
Come on up here. What a sad commentary that I have to have the mother of a 25-year-old come up here.
Hey, Costanza down here.
Your name, ma'am?
Miss Patricia last name's Minay.
I don't know what to do with your son here.
I don't know what to do with him either, Your Honor. He's destroying his life.
When's the last time you worked?
About 2 weeks ago,
Where?
improvement, home improvement company that I usually work.
What's the name of it?
Napier's.
How long did you work at Napier's?
I've worked there, probably about since I was 19.
6 years. How many hours do you? Yeah, I don't know. On and off. How much on and how much off?
Just like 2 times I was, and plus like seasonal when during the winter you don't work, so I have to find other things to do during winter.
Is he living with you?
Yes.
Get used to it.
That was just recently, within the last few months.
Where were you living before that?
I was with my girlfriend and the kids.
You got kids too.
I have 3 children. Yeah,
So you're fooling around with all these drugs. You don't show up in court. You got 3 kids. You're acting like a little child out in your car. It's time to grow up. I don't know what to tell you.
you're completely right. And that's
Well, then stop
why I
acting
wanna
like a
stop
bit.
That's why I want to stop running from it. I really do. It's I can't. I've been
You're scared.
struggling.
Don't be scared. It's okay to say you're
yeah,
scared.
I'm afraid. I've been struggling with this.
Judge, he's
with the
so he's not
substance
sliced.
for
Wait a minute. Slow down. Who's talking here?
He's been trying to get through a detox twice, Judge. He's been in
I
rehab.
did it.
Wait, why are you interrupting your lawyer?
I'm sorry, sir. I'm sorry.
According to Mr. Minock, Judge, he's twice tried to detox. He's been in patient rehabilitation, and he's unfortunately.
When's the last time you used? Tell me the truth. Don't lie to me. Tell me the truth. Don't lie to me.
3 years ago.
That long ago?
Yes.
You sure it wasn't yesterday?
No.
Sure it wasn't this morning?
I put that. I didn't know it was not this
What did you use?
heroin.
Yeah, I mean, why
I
not?
mean, yeah, no, that's not.
You're just playing Russian
Obviously, I
roulette.
don't want to say that. I know.
You're playing Russian
I know
roulette
I'm
with.
making horrible choices, and I've been making horrible choices. I can't change the past or what I've done. You know, I wish I could. And I'm not trying to have a sob story or make you feel bad for me because nobody should, because I'm doing it to myself. But if there's any possible way that I can make the steps forward to prove to you that I do want to change this and get and put all this behind me, I will do whatever it takes.
Now you're saying that because you know you're in deep trouble because you didn't.
Yes.
Why do you keep interrupting me? Do I look like the kind of guy that wants to be interrupted all the time? I mean, did he do anything?
Nothing, Your Honor. I met with counsel just before he came in, went through the file. Unfortunately, 0 days of work program, no treatment, no 12 step. I wish I had something positive to say in regards to Mr. Minnick. I know you mentioned earlier he's got 13 counts. I do want to make sure I try to highlight the file. He does have the non-technical violation as well. Just to point out, as far as being pleading guilty to a new offense, it's 14 counts. I don't have anything. I think he's over his 2 years as of July 27th.
Did you pre-try this case with Trenton this morning? The suspend charge? There was a suspend charge.
I only had just the one file, Judge. I wasn't giving you. I don't know that they had it. At all.
I mean, I think we need to go forward on this one way. So you want to talk to him or what do you want to do? If he wants to have a hearing, we'll give him a hearing. If he wants to plead guilty, he can plead guilty. If he doesn't, that's fine too. What's he want to do?
Can we have a few minutes, Judge? I'll come back.
Sure.
They would hang out until they're 3 or 4 months old. Then they just leave one day. They're all the feral cats.
Can you see it, please?
Quarterback session.
All right. Recalling Dylan Minnick.
Right to the pellet.
Dylan Blake Minnick, 243-643-449, A and B, and 23up, 240-232. Did you ever hear from Jennifer?
It is 1,500 now.
Yeah, that's right, though. Your name? Name?
Okay, Judge, may I forget that Mr. Minnick?
So what are we doing on this?
That Mr. Minnick will plead guilty to violation.
Is that what you want to do, sir?
Yes, but
You plead guilty here. Since this has been an absconsion, you've absconded, you could get 93 days. Do you understand that?
Yes.
And did you sign, read, and understand an advice or rights form here today?
Yes.
If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that? Nice and loud.
yes.
To the count one that you failed to attend your scheduled visit on September 12 of 23, how do you plead with probation? How do you plead, sir?
Guilty.
Did you fail to appear on that day?
Yes, Your Honor.
Count 2, that you failed to attend the court work program on August 12 of 23. How do you plead?
Guilty.
Count 3, you failed to provide proof of attending the victim's impact panel. How do you plead? Count 4, you failed to pay your fines and costs as ordered. How do you plead? Count 5, that you failed to refrain from violating a law, being convicted of disturb the peace in 2023. Count 6, that you failed to refrain from consuming alcohol or drugs, testing positive for fentanyl, heroin, THC, opiates, and meth on a chemical test of July 31 of 23. How do you plead?
Guilty.
Count 6, that you failed to submit to weekly testing on August 11. Nice and loud.
Guilty.
Count 7, that you failed to submit to weekly testing as ordered on August 16th. How do you plead?
Guilty.
Count 8, that you failed to submit the testing as ordered on August 22nd of 23. How do you plead?
Guilty.
Count 9, that you failed to submit the testing as ordered on August 29 of 23. How do you plead?
Guilty.
Count 10, that you failed to submit the testing as ordered on September 6 of 23. How do you plead?
Guilty.
Count 11, that you failed to submit the weekly testing as ordered on September 15 of 23. How do you plead?
Guilty.
Count 12, that you failed to provide verification of attending AA 3 times a week until an IOP. How do you plead?
Guilty.
Count 13, that you failed to provide proof of attending and completing intensive outpatient treatment. How do you plead? Did you fail to attend and complete outpatient treatment? I can't hear.
Guilty.
Yes or no?
Sorry. Oh, yes.
Did you fail to attend AA 3 times a week until intensive outpatient treatment?
Yes, Your Honor.
Did you fail to submit the weekly testing as ordered on September 15, September 6, August 29, August 22, and August 16, and August 11 of 23?
Yes.
Did you fail to refrain from consuming alcohol or drugs, testing positive on July 31, 23 for heroin, fentanyl, THC, opiates, and meth?
Yes.
Did you consume those substances, say within the 1 week before that test?
Yes.
Count 5, that you failed to refrain from violating a law, being convicted of disturb the peace on August 31 of 23. I'm sorry, were you in fact convicted of disturb the peace on August 31 of 23? Offense date August 1 of 23.
Yes, sir.
Did you fail to attend your scheduled probation visit on September 12 and your court work program date on October 12 of 23?
Yes, sir.
Need Beth. Did you fail to provide proof of completing victim's impact panel?
Yes, sir.
And did you fail to pay fines and costs as ordered?
Yes.
Anybody force you to plead guilty?
No, Your Honor.
Please are accepted to all those counts. And then I'll take the no ops counsel on, this is 24T643449B. He's going to plead to no ops. They're going to dismiss the suspend and fail to signal. True?
Correct.
Is that what you want to do?
Yes, Your Honor.
If you plead to no ops, special penalties are up to 100 fines, 90 days jail, costs are all those. Do you understand that? I can't hear you.
Yes, sir.
No. And did you sign, read, and understand and advice of rights again?
Yes, Your Honor.
If you plead guilty, you're giving up all those rights. There will be no hearing or trial. Do you understand that?
Yes.
To the charge, no valid ops on person. How do you plead?
Guilty.
Were you operating a motor vehicle on King near Grange and Trenton, July 25 and 24 at 1:41 p.m.?
Yes, sir.
And did you have a valid license on your person?
No, Your Honor.
Okay. Are you on probation or parole right now, besides this case to me?
No, Your Honor.
Anybody force you to plead guilty?
No, Your Honor.
All right. Please accept it to no ops. That's file B. The suspend is dismissed. The fair to signal and observe is dismissed pursuant to stipulation of the parties. So I'm taking the plea to no ops, dismissing the suspend. That's on 449B. And I'm also dismissing the fair to signal and observe. So I'm going to sentence him on probation violations in this case, the no ops. Anything you'd like to say? Let's talk about the no ops first. Anything?
No.
Sir, anything?
As far as the no operation.
No.
All right. Do you want to say anything, counsel, on the multiple violations he's got here?
Judge,
On 240232.
in addition to these things that were made on the record earlier this afternoon, that just that Mr. Minnick obviously, I believe, is at a point in his life where He understands that he can't sleep around with his problems the way he's been doing before. Again, he's got 3 minor children of his own with his girlfriend. In addition to the minor children that she has from previous relationships, they all live with the minute. He's responsible for their financial support and well-being. Judge. He's trying to get his life together. He's made several attempts, Judge, to do inpatient treatment as well as detox. Unfortunately, he relapse. So obviously, he does admit his knowledge that he does have a problem with substance abuse, Judge. And he knows that if he keeps going the way he is, unfortunately, he may not be around. So
Lisa, is that amount still true? 1285?
Let me check.
Sir, anything you would like to say?
First off, I'd like to apologize for holding the first time out with this outbreak.
That's fine. Don't worry about it.
Judge, I show 1671. There's late fees and a suspension's been added.
Okay. Go ahead, sir.
Also, apologize for also interrupting you.
You're fine.
Many times. I also just wanted to see if maybe you would possibly consider, it may not be an option now, because I don't know how the court works, like when it comes to stuff like this. They mentioned rescheduling just the sentencing or the hearing. I really just wanted to see my boys because I was supposed to see them and talk to my boss and make sure I could still have my job when I get out. I'm not running from this no more. If that was even a possibility, I'd be here on the time that the next scheduled time, and I just wanted to see if maybe you could possibly consider it, sir. And that's really just because I just want to see my kids and secure my job, so I'm not bad anymore. Is that next time? And I know I'm wrong, and I just hold more accountability and responsibility for the things that I've done. And I'm trying to turn it around so I can better my children's lives, my home, and everybody around me, and stay living.
If she does have a order here for support.
On 242, do you want to say anything?
I don't think I can add anything other than what I said earlier. It sounds like he's not living with the children. Sounds like he's living with his mom. He wants to secure a job, but he hasn't worked for 2 weeks.
Oh, sorry.
So at this point, I don't know what else to say. We're past the 2 years. I feel for Mr. Minnick. I wish him well, but I think delaying any type of sentencing, he's already absconded for 2 years, not just on this file, but other files. I think it's disservice if we adjourn it out, and I'm afraid he might go use, and I'm really afraid that it might be the end of his life if he uses, if he's not in custody today.
Probation's revoked. You're to pay costs of $1,500 and serve 93 days. Credit 1 for 92. If you pay costs of $1,500, I'll suspend 47 of the 92, and you'll only have to serve 45 days. So if you pay $1,500, you'll serve 45 days. You have a bond of $7,500, 10% that appears to be in your mother's name. She can apply that. You also have another bond that appears to be in your name on the no ops, and I'm going to just apply that money either way, Lisa, to the fines and costs outstanding on the drunk driving. And that is, on that case, I'm simply going to go $100 fines, 100 costs, 75 victims' rights, $50 justice assessment. So your total there is 3 1/4 or 30 days, and I'll run that concurrent. With the drunk driving. So you're going to serve 45 days if you pay $1,500. Otherwise, you're going to serve 90. You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer. Understand all of that? Good luck. Thank you.
He's doing Judge Hessler's.
yeah, he's got a coordinate. He's got a case.
That's fine. Don't let them monitor it.
Thank you, Judge.
Thank you.
Chris and take it down to Lisa. Yeah, no problem. And we are on the record in matter on the radio. For Mr. Boonville. He's in, where? We're on the record in the matter of the state of Michigan first. Thaddeus Pruden III, 251222. Council, we're just waiting for their client, their minutes. All right, Council, your appearance for the record, please.
Thank you, Mayor. Please support Rodney Williams on behalf of Mr. Thaddeus.
All right, and Mr. Green, please unmute, continue for the record. Mr. Byrne, please unmute and state your name for the record, please.
Sorry, man. Thaddeus Sorrell Broom III.
Okay. All right, and so council, you're requesting an adjournment as you were just spot appointed in this matter.
Correct. I talked to the prosecutor and he had no objections to that.
All right, we'll adjourn this to September 4th at
I'm on the court meeting right now, man.
what platform?
No, not with your phone.
Excuse me, you're on the record. So whoever's speaking with you needs to stop speaking because you're ruining the record here. What time, Nelly? 10:40. 10:45. Does that work for you, council?
That's perfect, Your Honor.
All right, and sir, Mr. Brown, if you were to test right now, what's in your system?
Say it again, ma'am.
I'm sorry, what?
You should say it again, ma'am.
You're telling me to say it again?
No, I'm saying say it again because I didn't hear you.
Okay, so sir, perhaps you should ask me to repeat myself. I'm not
I'm sorry.
in this talking too casually, okay? If you were to say now what is in your system?
I can't hear anything.
Sir, if you were to test right now, what would be in your system?
Oh, probably just a little bit of marijuana.
Okay, when's the last time you used that little bit of marijuana?
Yesterday.
Okay,
I believe.
you're not supposed to consume any alcohol or drugs that are not prescribed. Do you have a valid prescription for marijuana, sir?
Yes, I do.
You do?
Yeah, I got a weed license, a marijuana license.
You do? Okay, so you need to email that card into the court, okay?
Okay.
And our email address can be found on our website, sir. You have to email that in by 2 p.m. today.
Today?
Yeah,
You said I got to come up there?
yes, sir. You need to email it in by 2 p.m. today.
Oh, okay.
Okay? All right.
The license, the marijuana license. All right.
Sorry, what is that, sir?
The marijuana license, right?
Yes.
Okay.
The court will see you next week. Finding a condition are continued. Thank you. Have a good
Thank you.
day.
Thank you.
Okay. Let's go. You have the Whitmer files to be the content of Mr. Mahara. Oh, okay. Just remember, I just wanted you to, when you receive the invitation to join the breakout room, just hit join, okay? Okay. All right, be here. All right, we are on the record in the matter of the city of Chicago State Hills 25649. Also, Mr. Mihas, is this your family?
Yes, sorry about that. So you're dealing with Mr. Mahana. My fault.
I called case.
Okay.
All right, counsel, your appearance for the record, please.
Eric Mias, me of students.
All right, thank you, sir. Your name for the record, please.
Eric John Mills.
All right, today's date scheduled for a pretrial as well as a bond violation. So let's handle the pretrial first, counsel.
Your Honor, the government and I have come to an agreement that is acceptable to Mr. Mills. They will be dismissing the count of OWI high BAC. We're pleading to count of visibly impaired. With an agreement for reference referral to Very important.
Okay, council, I will let you know that their numbers are very, full, so I'm not sure what that looks like. So it appears though the plea is contingent on that. So you may want to look at some other courts as well. Right. The council, please let me finish and make a record, okay? You may want to look at some other, or treatment courts, specifically 19th district court, since your client resides in Dearborn. Ward. I'm just saying, indicating 25th district court, but as it appears though the plea is dependent on enrollment in treatment court, and I've just been informed this week that the 25th district court is at capacity, may want to look at other ones. Okay, and what was it you were going to say?
You're open to any court that doesn't have to be contingent to that specific.
Okay. All right, sir, please raise your right hand. You solemnly swear or affirm the testimony you're about to give this man the truth, the whole truth, and nothing but the truth. All right. And you heard the plea that was placed on the record, correct?
Yes.
As to the amended charge of operating votes to be impaired, how do you plead? Sorry?
Guilty, Your Honor.
And you've gone over your right to rights with your attorney, correct?
Correct.
And you understand all of those rights. You also understand by entering into who could be waiving some of those rights.
Understood.
And you understand the possible penalty as a result of your plea, but in this court and any other court or administrative agency. Knowing all that, is worth continuing to use plea. Anybody promised you anything, threatened you or coerced you in any way to enter into a plea? No. Any immigration issues?
No.
And counsel, if you can please, what are your clients?
It's your own folks only.
Main worth.
Mr. Mills, let me take you back to May 5th. 25. Do you recall being in Wyandotte on that dating time? Yes. And specifically, you recall being near Fort Avenue and 4th Street? Yes. At that time, were you operating your vehicle? Yes. And have you been consuming alcohol that night? Yes. And do you believe that the consumption of the alcohol impaired your ability to drive the vehicle safely? Yes. Nothing further, Your Honor. We'll stipulate that it was over 0.1.
In what way did it affect your ability to operate motor vehicle, sir?
I made speeding choices. This was the best case scenario that I'm standing here.
And I recognize that. All right. In the court, counsel, you indicated simply it's over 0.08 and the 0.204. Correct?
Correct.
For purpose of the plea. Court does find the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the amended charge. Dismiss the original charges from the plea agreement. Ask the fine violation, counsel.
Your Honor.
That your client failed to test as ordered on July 27th.
Yes, Your Honor. My client at that time had notified the testing agency that he was going to be on the other side of the state.
Hold on, because your client going to be guilty or not guilty?
He's going to plead guilty to it. He did the test. No, I didn't.
Okay. And so, sir, you're still under oath. So I ask the bond violation that you failed to test as ordered on July 27th on the plea.
Guilty.
All right. And you understand you do have the right to have a contested hearing in this matter by entering into a plea. You will not have that contested hearing. Do you understand that?
Understand.
And has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
And you understand the possible penalty as a result of your plea and bond violation?
Yes.
All right. Counsel, you can please mark your client.
Mr. Mills, you understood that you had to appear for thank you. Let me walk. At your last testing, did you notify the testing agent that you would be on the other side of the state?
No, counsel, I'm sorry. That would go to the allegation. Sir, as a condition of bond, you were placed on bond in this court July 24th, correct?
Correct.
As a condition of bond, you were ordered to participate in random testing, correct? And on July 27th, you did not test. Is that correct?
Correct.
All right. All right. Court counsel, be satisfied.
That's correct.
All right. The court is satisfied with the actual basis. The court has found the case no voluntary and factually accurate. Now, counsel is just sentencing on bond violation.
Your Honor, at that point, Mr. Mills had previously indicated to the testing agent that he was going to be on the other side of the state for the next couple of days. He was told not to worry about that as soon as he got back, he would test. He my understanding is that the probation department here had not had contact with them. He assumed, thoughtfully, that it was enough to a full testing agency that he was going to be unavailable for a couple of days. If you look at his complete record, this is the first time there's been any indication of non-compliance with determined probation. There was not an intentional one. When as soon as he came back, he did come in, did test. He's been clean since. So there's no indication that there was an intentional desire to cover up a positive or anything like that. I've explained to him thoroughly that in the future, if there is any kind of possibility with random testing, that you may not be in the area, you need to contact probation officer, the probation agency, pretrial services, in order to make it clear to them, since they are administrating this, not the testing facility. I think the lack of experience in this field for my client, it's credit to not have this kind of experience, is part of what led to this. It will not happen again. And the reality is groups will be putting on probation now that he is pleading to the underlying offense.
All right, so Mr. Mills, who ordered the random testing?
27-ish course part of that.
Right. So that's the only person that you need to notify. Is the court, not the testing agency. Yes. This is a scheduled trip, correct?
Yes.
Okay, and how long ago did you schedule it?
Probably 2 weeks before my last court.
Okay, so then why 3 days before you were leaving, or 3 days before your testing, did you not inform the court that you were going to be out of town?
So I was in here for that day, and I was not sat down with anyone from probation. I was given a sheet of paper to provide to the testing facility. I assumed that the testing facility was an extension of this court. I understand that now. I didn't know any better because I've never done this before.
Okay, sir, that wasn't my question.
Sorry.
You were here in court on that day. You did not mention anything about being out of town. Did you?
No.
No. So if you had, you could have addressed it at that point.
Your Honor, if I may.
Yes.
The only thing with that is, as we go through that colloquy, the emphasis is usually on being out of the state. And so in the future, from my point of view, I will make sure to address that with my clients, to say, I don't care that they say out of the state. If you're taking a trip where you'll be indisposed and unable to test, so that I can make sure that we don't have this kind of issue with future people as well.
All right. So, counsel, did you contact or communicate with probation that your client was going to be going out of town?
I was unaware. And that's why we'd be more annoyed.
You need to give, but you're unaware of your client going out of town?
Correct.
Okay.
And I did not ask because I think he was out. He was going out of the state.
Okay. The court's going to order $100 fine. You pay that today, sir?
Can you take a card?
Credit card.
Yes, the court accepts payments. Okay. Or the court accepts. All right, sir, I'm going to have you stop over at probation. You're going to get a link for your needs assessment. You're going to receive a documentation regarding the guide for your PSI, as well as your date for your PSI and your date for sentencing. Counsel, you can coordinate that with your county.
Excellent.
Thank you. Have a good day.
Thank you.
You're on. Go off the record. All right, we are on the record in the matter of the state of Michigan versus David Brochet, 25893.
Ready.
Good morning.
Good morning. I'm Greg Boulahanis, B36431 on behalf of David Brochet. Your Honor, I would say that we would waive the formal reading of the complaint. My client stands mute for purposes of arraignment. And fortunately, we're able to resolve the matter with Mr. Mohammed.
Okay, very good. Thank you. And so, Mr. Brochet, your name for the record.
David Brochet.
All right. Thank you. Thank you for addressing appropriately for court. And counsel, as to the resolution.
Your Honor, Buster's moving to dismiss the original charge of IBEC in exchange for my client pleading guilty to operating while visibly impaired, and we're prepared to do the voir dire after you advise on those rights.
All right, thank you, sir. Please raise your right hand. Do you solemnly swear or affirm the testimony about to give this matter the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, you heard the plea that was placed on the record, correct?
Correct.
As to the amended charge of operating while visibly impaired, Harley plea.
Guilt.
And you've gone over your advice and rights with your attorney, correct?
Correct.
And you understand all of those rights.
Yes.
You also understand by entering into a plea that you'll be waiving some of those rights.
Yes.
And if you got over your possible penalty as a result of the plea, whether in this court, any other court, or administrative agency.
Yes, I have.
Knowing all that, you want to continue with your plea. Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No, yeah,
Also, if you can please mark your client.
sure. Mr. Borche, we operate a vehicle in the city of Wyandotte on June 22nd, 2025.
Yes, I was.
And prior to operating the vehicle, did you consume alcohol?
Yes, I did.
And what type of alcohol did you consume?
I had one beer and a couple strong shots.
Okay, and then was that of liquor?
Yes.
Okay. And due to the consumption of the liquor, did that contribute to your speeding of your vehicle?
I believe it did.
Okay. And you were given a BAC, and the BAC was 0.08 or more, correct?
Correct.
Okay. It's gonna be like 0.80, correct? Okay. All right, and so the court does find the plea was knowing voluntary facts the act of court accept your plea, being the charge, this the original charge is for the plea agreement, and asked to bond counsel.
Your Honor, Mr. Borche has abstained from alcohol since the date of the incident. I do.
Correct.
May I see your AA?
Okay.
Yep.
He's been attending AA twice a week. And here on this side. AA is under the shoe. And he has no priors.
Correct.
Okay, what was that? What was the 1993 out of the 24th District Court in Allen Park? What was that?
And that actually was a DUI.
Oh, I'm sorry.
I figured you probably didn't know that.
Maybe.
Well, it shows traffic offense, and so I just wanted, I wasn't sure what that was, so
I'm sorry.
that's okay. If you knew that, you wouldn't have said that there were no players.
Yeah.
That was 93. Correct.
Yes, it was.
Yeah, that's all.
But you represented your attorney that there were no priors, so that's what he put forth. So I just wanted to verify for the matter.
Okay.
So, sir, if you're to test right now, what is in your system?
0.
0, anything?
Yes.
Okay. And are you currently out on bond in any other jurisdiction? All right, you're not on probation or parole anywhere, correct? And where is it you work, sir?
The Baldwin Public Schools.
Okay. Well, that's a far drive.
Carlton.
Yes. And all right. And if you ever fail to appear in court, all right, the court's going to order your cash bond will be continued not to possess and consume any alcohol or drugs unless prescribed. Are you going to go over probation? You're going to receive a copy of the bond conditions. You're going to receive your need for your needs assessment. You're going to receive paperwork for your PSI and your days for your PSI, as well as your sentencing date. Okay.
Okay.
All right. Good luck to the start of school, and just have a seat information. Somebody will be with you shortly. Okay.
Thank you.
Thank you. Have a good day. All right. And we are on record in the matter of the submission of Joshua Jamula, 25994.
Good morning, Your Honor. Greg Bulahanis on behalf of Joshua Jamula.
Good morning.
6431.
All right. Good morning. And Mr. Jamula, your name for the record, please.
Joshua Daniel.
I'm sorry.
Okay. And counsel take the date scheduled for the arraignment and field trial of this matter and ask the arraignment.
My client waives the formal reading of the complaint, stands mute. We'd ask the court to enter a not guilty plea on his behalf.
Court waives the formal reading of the plea of not guilty. Someone will be arraigned and ask the pre-trial.
Thank you, Your Honor. Your Honor, we're able to resolve this matter this morning with Mr. Mohammed. Prosecutors moving to dismiss the original charge in exchange for my client pleading guilty to operate while visibly impaired We're waiting to put the proofs on the record after you advise them of his rights, which I've already advised them on several occasions.
Okay. Sir, please raise your right hand. Do you solemnly swear or affirm testimony you must give this matter to be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
All right, you heard the plea that was placed on the record, correct?
Correct.
As to the amended charge of operating while visibly impaired by alcohol, how do you plead?
Guilty.
You've gone over your advice and rights with your attorney, correct? No. I don't know. You need to speak out.
Oh, sir.
And you understand all of those rights.
Correct.
You also understand by entering into a plea that you'll be waiving some of those rights.
Yes.
You understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes.
Knowing all that, do you want to continue with your plea? Has anybody promised you anything, threatened you or coerced you in any way to enter into a plea?
No.
Any immigration issues?
No.
And counsel, if you could please report here your claim.
Sure. Mr. Jamula. Yeah, right there.
Okay.
We're gonna bring a vehicle on the city of Wyandotte on May 30th, 2025.
Yes.
Started operating the vehicle to consume any alcohol. What did you consume and how much?
Vodka seltzers and for example.
Okay. And did the consumption of the alcohol visibly impair your ability to operate your motorcycle?
Yes.
And there was a issue in the report and on the vehicle regarding the did you fail to completely stop at a red light before making a right hand turn?
Yes.
Your Honor will stipulate that his again that his BAC is 0.08 or more. And then I think that would conclude the proofs.
All right, and counsel, I showed there was blood tests. Do you have those results? I don't show those in the file.
No, it's not a blood test. Oh wait a minute, hold on.
Yes, it was.
Hold on. Yes, policy.
They did do a PVC, and then they
I got it.
blood test.
This 0.190. Do you need to see the?
190.
Do you need to see the?
Oh, that's great. I think we're just time to please no acknowledging it's actually accurate. The borough accept your plea to the amended charge, the original charge for the plea agreement. And counsel asked you bond.
Mr. General, your issue. Okay. He's been doing AA. And he's been documenting it twice a week. Would you like to see it?
Okay, I will say that, yes. You don't have a sheet, sir? Do a sign-in sheet?
I wasn't. It's uncomfortable.
I have a documented on it by writing a paragraph about each meeting as well as the Zoom ID, the time, the day, like a journal.
All right, I'm not reading any of this because I know it's confidential, sir. I'm just looking at the dates. That's all that I'm doing. So, all right. So tell me something you learned about from that, sir.
I definitely understand the process of AA. It's very helpful for me because it's shown me what's more important for my health and safety. I like to understand, and the people that I'm involved with, they are really good people, and it shows me that more important than me being out and about drinking and not being intoxicated. I'm spending more time with my family, and it's better. It's very better.
I have to tell you, the amount of individuals that are in front of this court for operating while under the influence or intoxicated, high BAC, whatever it is, I am astonished. Especially with all the ride-share options that there are. Uber, Lyft, I mean, e-bikes, whatever it may be. It's unbelievable. All right. And sir, where do you work?
I work at Professional Sprinkler. It's fire protection.
Okay. Have you ever failed to appear in court for any reason?
No.
All right. Are you currently out on bond in any other jurisdiction?
No.
And then you're not on probation or parole because you've done a running felony. All right. Before you put an order, $7,500 personal bond, not to possess and consume the alcohol or drugs in thus respect. And you are going to go over to probation, sir. You're going to receive a lot of probation. You're going to receive a copy of your bond conditions. You're going to receive the link for your needs assessment. You're going to receive a copy of information for your PSI. You're going to also have your PSI date as well as your sentencing date. Okay. You have a good day, sir.
Thank you.
You're welcome. And we are on the record in the matter of the state of Michigan versus Nicholas Bonet, 25206.
Good morning, Your Honor. Greg Mullahanis, P36431, on behalf of Nicholas Bonet. Today's I'm engaged for sentencing. We've reviewed the PSI. There's no additions, corrections, or deletions. Your Honor, I'm glad to report. I believe he's been accepted for the sobriety court for 25th District Court. He got in right under the deadline when they just before they stopped the continuing the interview. He's very fortunate and he has been here today as support, and he's looking forward to participating in this fight.
All right, and sir, your name for the record, please.
Nicholas Bonet.
All right, and thank you for addressing the police report. The court does find your report recommendation. Mr. Bonet's acceptance into the 25th District Court Treatment Court that there is reasonable grounds for charge on CL 769.5. The court also finds the following sense to be in the best interest of justice here, reasonable and proportionate to the seriousness of the matter, taking into account the circumstances surrounding Mr. Bonet. And counsel already had you already had your client sign this, and then the prosecutor also has to sign this as well.
It's transfer order.
Yes, the MOU.
Sure.
And so the courts were already served purchase it to complete and comply with all terms and conditions in front of the district court Supreme Court. Any questions regarding that?
No, Your Honor.
All right. The court's going to order $500 fine, $100 screening assessment fees. There's no oversight fee at this court because you're paying that as a treatment court. $50 cost of prosecution. Plaintiff's assessment fee of $75. Justice's assessment fee of $50 for total $1,025. There's also the $1,080 for the 25th District Court. That will pay over there. This MOU has you paying this court's fines and costs over here. The treatment court's fines and costs over there. Okay. So
He's prepared to pay that today.
okay. So you didn't post a bond of $500, so you'd have to additional $525 out of pocket. You have that to pay today?
Yes.
Okay. All right, I've already have you stopped the window.
Do you need us to sign that now or at the probation office?
I need the probation office.
Okay.
Yes.
Thank
All right, good luck to you, sir. Have a good day.
you. Staff, have a great day.
Thank you. We're on the record in the matter of the state of Michigan versus Tamara Whitner, 25674.
Yes,
Mr. Mahalo?
I did not want him.
Okay, just pulling over, Judge, 1 second.
That's all. You're
Good morning.
zoomed into court.
Good morning, Your Honor. Nijad Mihan appearing on behalf of Ms. Whitmer, P59371.
Ms. Whitmer, I cannot have you speaking right now. Just one moment. Counsel, are you really driving while you're locked into court?
I'm sorry?
Are you really driving while you're logged into court?
Judge, yes, I'm logged into Zoom with my phone set down. I'm not using my phone as I'm trying to get to another court.
Counsel, regardless of that, you should not be driving while you're zoomed into court.
Judge, right now I'm parked.
But you were not parked previously. Whitmer, your name to the record, please. Ms. Whitmer, your name for the record, please.
Temple Whitmer. I do not want him speaking up for me.
Did you not want this to be an
I did not want him as my attorney.
Well, ma'am, have you retained your own attorney?
What was that?
Have you retained your own counsel?
No.
Okay.
I did not want him, and she took his advice. The last judge.
I'm not sure what I'm speaking about.
The other judge took his advice when I said I didn't even want him.
Okay. Well, in this matter, ma'am, there's not a request for a withdrawal. There's not a request for anything. So Mr. Mihana is the attorney that's appointed to represent you.
That's not the one I want. I waived it.
Well, ma'am, based upon the report that's been received from the Center for Forensic Psychiatry, you are not competent to waive your right to an attorney. So
I do not want an Arabic representing me.
You do not want what?
I do not want an Arabic representing me.
Ma'am, there's some discrimination going on here at all. Is there something that Mr. Mihana has done incorrectly?
I didn't want his opinion.
Okay, well, given the determination from the Center for Forensic Psychiatry, Ms. Whitmer is not competent to stand trial, and the court has some concerns for her competency as well. And Mr. Mohammed, are you? He's not right down. Okay. Into the main session. Thank you. And counsel, it's my understanding that the attorney has stipulated an evidence report on Ms. Whitmer's lack of competency, but likely to attain competency, correct?
Yes, Your Honor.
Clear appearance for the record, please.
I'm sorry.
Good morning, Your Honor. Mohammed on behalf of the people.
All right. And Mr. Mohammed, you and Mr. Adam has written to the competency report that determined from the Center for Forensic Psychiatry. Mr. You said walk around, please, and say unit that Ms. Whitmer is incompetency in trial and likely to attain competency if provided first of treatment for the time limit established, correct?
Correct. There's a stipulation to the report.
All right, the court is going to adopt that recommendation. The court does find Ms. Whitmer's incompetency in trial likely to attain competency provided a course of treatment within the time limit established by section 1034. The court is going to further order that the Center for Forensic Psychiatry is to get Ms. Whitmer a bail for treatment ASAP.
Thank you.
Anything else, counsel?
Yes, Judge, we need a review date.
The court will set this for October 30th.
October 30th.
At 9 a.m. Counsel, please.
Why is this being prolonged? Why is this prolonged?
Ma'am, it's not prolonged. That's a review, so this court can.
This is taking too long. I want to go to sentencing. This is taking too long. I want to go to sentencing. This is taking too long. This is dragging it out.
Excuse me.
Dragging it out.
Please stop talking for a moment.
That's October 30th. That's too long from now.
Yeah. Let me explain something to you. There's not going to be a sentencing because you have not guilty to anything because you are not competent to do so. So this court has.
I'm not going to a hospital to prolong my course.
Stop talking.
I'm not going to a hospital to prolong this court case. Court case. I've been here since May.
Okay, well, I'm just using her so I can make a record. So she wants to listen, she can listen. If not, that's her problem. The court has determined that Ms. Whitmer is not competent to stand trial. The court has ordered the Center for Forensic Psychiatry to get Ms. Whitmer a bail as soon as possible so she can receive treatment. The court has set this for a review on October 30th at 9 a.m. so the court can determine that Ms. Whitmer has in fact received her bail so she can begin her treatment. So there will not be any sentencing as you have been deemed to be incompetent, and the court has accepted that determination from the treating psychiatrist. We'll see that October 30th. Thank you. Have a good day.
Thank you.
Let's go off the record for a moment. All right, we are on record in the matter of the city of Wyandotte versus Christopher Benavides, 251265. Council, your appearance for the record, please.
Good afternoon, Your Honor. Your Honor, John Goldport, P 30758 on behalf of Mr. Benavides. Mr. Benavides, please put your name on the record.
Christopher Craig Benavides.
All right, today's date for the arraignment is your client is in custody. Council asks for the arraignment.
Your Honor, he was standing for the charges, waiver for reading of those charges, asked to plea of not guilty plea.
The court waived the formal reading, enter plea of not guilty for purpose of the arraignment, schedule this matter for pre-trial on September 10th. Council.
This is a,
Sorry, 10:45? Yes. What's that?
September 10th, Wyandotte case.
Yes.
Yes.
All right, and council as to bond.
So just regular legal step. As to bond, Your Honor, Mr. Benavides does have some prior contact with the criminal justice system. However, he's not on probation nor is he on full at this particular time. He did have a number of warrants in the Third Circuit Court. As he's informed me, he has cleaned all of those up. There may be one that he has to handle or is supposed to handle tomorrow. I'm not exactly sure of that. He's single. He lives with his father. He's 35 years old. He has never, as I've indicated, he's not on probation nor is he on parole at this point in time. And he is gainfully employed with electrical local 17. We're asking for I believe he may have, I'm not sure, but I believe he may have a drug-related incident. I'm sure.
Oh, yes. Also, sir, what's going on in your matter in Wayne County with Wayne County Sheriff from August 20th, just 8 days ago? Assault and battery is the charge? Hello? Yes, sir. What's going on from August 20th?
The old warrant, the one that I just cleared up.
I don't know. It says August 20th, assault and battery, sir. Wayne County Sheriff.
Oh yeah, that was from years ago, and I went to I got dealt with that couple of days ago, and I got court for it tomorrow.
All right, sir. If you're going to test right now, what's in your system?
Sorry, I didn't hear you.
If you were to test right now, what is in your system?
Methamphetamines.
All right. You see he works, sir?
He works for the electrical union, local 17. Electrician.
Are you currently working or are you laid off, sir? What's the status of that?
I'm currently working. I'm actually going for my CDL. They're putting me through a CDL school.
All right, given your criminal history, given your current criminal charges as well, the court is going to order a $3,500 10% bond. In the event you post bond, you have to possess or consume any alcohol or drugs, and you would participate in random testing. In the event you post bond, you need to contact the 27th District Court Probation Department just to get set up for your testing. Any questions?
Thank you, Ron.
You're going to do that within 24 hours of your release. Have a good day.
Thank you.
Thank you. All right, so Officer.
That's late.
We will go on the record in the matter 23 CF 158, State of Wisconsin versus Robert Canfield. The state appears through District Attorney Kevin Schmidt in person. In person, we have Mr. Canfield appearing in person in custody without counsel or with counsel Nicholas White. We're set today for a plea and sentencing. This appears to be an OWI 7th. Is that correct, Mr. Schmidt?
Yes.
All right, Mr. White, what is the agreement that's been reached?
Thanks, Judge. There's an offer here for plea to the OWI 7th, count 1, and also the attempting flee or elude an officer, count 2, merge and dismiss, count 5, dismiss and read in counts 3 and 4. The there's an option of requesting a PSI or not. We plan to waive the PSI and have a joint recommendation for the statutory minimums on the OWI 7th with a minimum of 3 years initial confinement on the prison sentence there, a concurrent sentence on the flee or elude charge, court cost, and supervision to include AODA and follow through.
All right, thank you. Do you have a plea questionnaire?
Yes, I do.
Mr. Canfield, that's the agreement that you've reached with the state?
Yes.
I have in front of me a plea questionnaire waiver of rights form. Do you recognize this document?
Yes, I do.
Did your attorney go over this document with you?
Yes, he did.
Did he go over it thoroughly with you?
Yes, he did.
Essentially, did he read it to you word for word?
Yes.
And so you understand everything on this document.
Yes, I do.
If you didn't understand something, did you have him explain it to you until you did?
Yes, I did.
Is that your
Your Honor.
signature on the second page?
Yes, it is.
You are pleading guilty to one count of OWI operating while intoxicated, 7th offense, and attempting to flee or elude an officer. Is that correct?
Yes, it is, Your Honor.
You're 36 years old. You have 12 years of schooling. You can read, write. You understand the English language. That's all correct.
Yes.
You have not had any alcohol, medications, or drugs within the last 24 hours and no mental illnesses or defects, correct?
Correct.
Did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt to both these charges?
Yeah, we went over quite a bit of stuff, so I think so.
Did your attorney go over with you the maximum possible penalty you face for both of these charges?
Yes.
Because you're charged with crimes, you are entitled to constitutional rights, and each of these rights is listed on the front page of this document. Did your attorney thoroughly go over your rights with you?
Yes, he has.
And do you understand them completely?
Yes, I do.
You understand that you will no longer have the right to a trial. You will no longer have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You will no longer have the right to testify on your own behalf or remain silent and not have your silence used against you. You will also no longer have the right to have that jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you will no longer have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of those rights you're giving up here today?
Yes, I do.
You understand that if you're not a citizen of the United States, your pleas could result in your deportation.
Yes, I do.
You also understand you're pleading guilty to felonies. As such, you will no longer be able to use or possess a firearm for life.
Yes, I do.
You will no longer be able to vote in any election until your civil rights are restored.
Okay.
And you understand that?
Yes, I do.
All right. Do you also understand that with regards to this matter, the state would have to prove on or around August 28th, 2023 in Burnett County, Wisconsin, you operated a motor vehicle while under the influence of an intoxicant, a class F felony, and this would be counted as your 7th offense. Do you understand what the state would need to prove?
Yes, I do.
You understand the maximum possible penalty could be a fine of up to $25,000 or imprisonment of up to 12 and a half years or both.
Yes, I do.
You also understand that with this sentence, there is a mandatory minimum and the court shall impose a bifurcated sentence of the confinement portion to not be less than 3 years of initial confinement. Do you understand that?
Yes, I do.
Do you understand that with regards to count 2, attempting to flee or elude an officer, the state would have to prove the same date, the same time, the same place, that while operating a motor vehicle on a highway after having received either a visual or audible signal from a traffic officer, a federal law enforcement officer, or a marked or unmarked police vehicle that you knew or reasonably should have known was being operated by a law enforcement officer, you knowingly fled or attempted to elude a traffic officer by increasing the speed of your vehicle in an attempt to flee. Do you understand what the state would have to prove?
Yes, I do.
You understand the maximum possible penalty could be a fine of up to $10,000 or imprisonment of up to 3.5 years or both.
Yes, I do.
You also understand that upon conviction, the Department of Transportation shall revoke your operating privileges for 6 months.
Yes, I do.
Now, do you also understand that there is an agreement here between the parties for a recommendation to the court of the mandatory minimums as it relates to that OWI 7 and to have a concurrent sentence for that flee and elude. Do you understand that I'm not bound to follow that recommendation?
Yes, I do.
That means I could sentence you to the maximum possible penalty if I thought it was warranted. Do you understand that?
Yes, I do.
Do you still wish to proceed and enter a guilty plea?
Yes, I do.
Now, did you review that criminal complaint with your attorney? And in particular, there is a section there called the probable cause section, where it basically says what happened that day and why you were charged with these crimes.
Yes, I do.
For the most part, are those facts accurate?
Yes, they seem like it.
And so you're admitting here today that you, in fact, did operate a motor vehicle while under the influence of an intoxicant, 7th offense.
Yes, I do.
And you're admitting here today that you, in fact, did flee and elude an officer.
Yes, I do.
Are you pleading guilty to these charges because you are guilty of these charges?
Yes.
Mr. White, may the court use the probable cause section of the criminal complaint with the statements made by your client to find a factual basis?
Yes, may, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty to these charges?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes.
and voluntarily?
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
As far as I know, yes.
And has he discussed with you a potential of possible defenses or a lack of defenses you could have in this case?
Yes.
Did he talk to you about the discovery, that evidence, information that he received?
Yes.
Did he also talk to you about what could happen if you were to go to jury trial?
Yes.
Are you satisfied with his services?
Yes.
Any questions for the court or for your attorney before I proceed?
Not that I can think of.
As to count 1, OWI 7, the class F felony, how do you wish to plead?
Guilty.
As to count 2, vehicle operator flee or elude an officer, a class I felony, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of count 1 and count 2. Counts 3 and 4 will be dismissed and read in for purposes of sentencing. Count 5 will be dismissed and merged in with count 1. Judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Schmidt.
Judge, I think this is a case where the court should be doing the minimum of confinement, 3 years initial confinement, and then suggest 3 years extended supervision, run the other case concurrent. You probably noticed on this one in the criminal complaint, there's something peculiar with Mr. Canfield's history. First of all, his history is only the OWIs and driving inimical to public safety, which is Minnesota's version of driving without a valid license or driving while revoked. Every single one of his OWIs occurred between 2016 and 2018. So they were all within a 2-year period of time. He was sentenced on them all around the same time. At the same time, he was committed 3 different times civilly for mental illness. He's been found not competent for unspecified schizophrenia or psychotic disorder multiple times. I think in this case, the timing of those commitments, 2016, 2018, 2020, and when those past OWIs occurred and the gap that's occurred since then, 2018 now to 2024, 2025, I think that demonstrate that there's a connection between his drinking and driving and maintaining mental illness and treating that. I think when he is treating it, he probably is much less likely to commit this offense, which I know is kind of unusual with this type of offense. So for that reason, I think the lower confinement period is appropriate. I think the real goal is to get him on supervision, to monitor, to make sure he's taking whatever medications he needs, he's acting cogently, he's acting sober. And for that reason, I think this is the sentence that best will appropriately address him. Additionally, one thing I talk about a lot when we talk about sentencing in OWI is the whole idea of the Wisconsin plan for the OWI sentencing scheme is we keep ratcheting up each conviction, higher and higher penalty. When you have a person who just racked them all up in a short period of time, all had them at the same time, it's a little different. Like even on his last one, he only got 193 days jail in that. So he hasn't had the ratcheting up you'd have in Wisconsin because Minnesota's scheme works a little differently. So for those reasons, I'd ask the court to follow the agreement. Thank you.
All right, thank you. Mr. White.
Thank you, Judge. Looking at the charges here, it's no doubt this all very serious, especially with the underlying facts. There's a high PAC that was received by the lab. That's merged in count 5, but it's a fact nonetheless. Not going to spend much time talking about the facts here. It's not good. What I can talk about is my client's taking accountability. And today he's going to be sentenced after this case has been pending for about 2 years. There is some interesting information there looking at his history, like the prosecutor brought up with the OWIs and competency all happening right around the same time in 2016 to 2018. I spent a good amount of time looking at the prior offenses here for Mr. Canfield because just starting with the dates that were given in the complaint, there's a missing incident date. There's 2 convictions on the same November 20th date. At first glance, it appears there's duplicate convictions, but I did look at the Minnesota history, each case by case. Unfortunately, this is a 7th offense. He did have 5 prior offenses in Minnesota. My understanding is that he still has some supervision to go on at least 2 of those cases. This is not over with today. However, the sentence goes. A strange kind of timing in this case is looking at a sentence credit and seeing. I think there was a failure to appear in May of last year, and an active warrant in Burnett County for failure to appear. During that time, my client was completing treatment in Kinnick Falls, an alcohol and drug abuse services, which is a halfway house in River Falls. He graduated that in August 2024. So it appears that even though he was on warrant for his arrest, he still was seeking help for these problems and what led him to the OWI. I know this information just because I have a certificate of completion. It was signed by the counselor there, August 1st, 2024. So just going to my client's character and rehabilitative needs, he has been attempting to address this throughout the last several years, and even since this incident happened, since he posted the bond. He graduated in March of 2024, which was just 2 months after he was released here, I think, that he completed New Beginnings Inpatient Program. That certificate was signed by Jeffrey Dalik. And then there's also just a letter from that same time frame from Mr. Rick Mann, March of 2024, a therapist just writing a letter on behalf of Mr. Canfield stating that he's attended many. Actually, he does not miss group or individual sessions. He's been in class and groups for days, sometimes the entire day, beginning to end, and he's benefited from that treatment program. I think it's the type of treatment program that helps him out the most. Your Honor, I'm asking you to go along with the minimum sentence here. I think that 3 years, it might not be the sentence that's going to work in every case, but this is going to be the longest amount of time my client's had in custody. And for those reasons and what he's done since the incident, I'd ask you to go along with a 3-year recommendation for confinement. I would also agree with a 3-year recommendation for extended supervision, concurrent on both charges there. Thank you.
Thank you. All right, Mr. Canfield, I'm now going to give you an opportunity to make a statement if you wish to do so. You don't have to, but it is your only opportunity to tell me anything you want about this case, anything about you, about your journey. But you don't have to. Again, I see that there is something written in front of you. I'm not sure if you're going to read something to the court, but if you do, please read it slowly so that my court reporter can take it all down, okay?
Okay. So yes, I do just want to say something short. I just wanted to let you know that I am truly sorry that I put people in the community at risk of being hurt and the officers. And as he mentioned, the treatment stuff, from February 21st to March 29th, I was at New Beginnings and graduated on March 29th, which is a high intensity inpatient. And then on March 29th too, I went to Kinnick Falls in River Falls, Wisconsin. And I went to treatment there for a little over 4 months and graduated on August 1st. And then from there, I was living at a sober house, part of the Servant of the Shepherd Church in River Falls, Wisconsin, up until I got picked up on this warrant. And I just wanted to let you know that my life was actually better than it's been in years while I was out. That's all I got. Thanks.
Thank you, Mr. Canfield. Mr. Canfield, I do commend you for the things that you did and the programs that you completed and that you focused on your sobriety and having a better life when you were absconding. Still doesn't excuse the absconding. That's why when you were, I believe you were picked up on the warrant, and that's why the cash is so high, because the court couldn't assure you appearance on the original. I can't recall off the top of my head, $4,000 or something of that nature, of what the original cash bond was set at. $5,000. That's a significant amount of money to lose. That's a lot of money to lose, Mr. Canfield. But that wasn't enough to assure your appearance. I wasn't aware of the mental illnesses or disorders that are affecting you. Here, you're not receiving treatment for them. That's what you put on the plea questionnaire, but you do have a history of mental health issues, and the state recognizes that. And so it's glad to hear that in the arguments and to take a different perspective. Because when somebody looks at an OWI 7 conviction, that's extremely serious, extremely serious. I don't know how Minnesota does it over in Minnesota. I do know that their first one is a crime, although Wisconsin's is not. But it doesn't sound like Minnesota is as strict or harsh or punishes as much as Wisconsin does for higher OWIs. If you're OWI 6, you only sat 163 days of incarceration. And now with an OWI 7 in Wisconsin, you're facing at minimum 3 years of incarceration. And that's not even getting to participate. You get no ability to participate in that initial confinement in early release programming. It's a mandatory minimum. This is serious. An OWI 7 is extremely serious. Even if in Minnesota, each and every time you could have put not only your life at risk, but so many other lives at risk. I just had a homicide by intoxication, by intoxicated driver sentence yesterday. Somebody could have died. You cannot ever take that back. I'm really hoping that you are focusing on your mental health and making sure that that's under control. It sounds like something went awry during that period of time, 2016 to 18, and then 24 and 2024. Perhaps you were not taking your medications as you should. Perhaps something else had you spiral, and then you weren't going to seek your mental health. Unfortunately, it has caused you to be in that seat, sitting in orange, now going to prison. As much as people may think, I don't like sending people to prison. It's not my favorite thing. I'm taking away your liberty. I'm taking away your rights. It's not something that judges look forward to doing. Especially when you have a mandatory minimum case and there's no discretion involved. Your criminal history appears only to be operating while intoxicated. And again, in that short little stretch of time, and then now in 2024 with this incident. You don't have a huge criminal history. You do have rehabilitative needs that you can seek services while incarcerated, but you need to continue to seek those services when you're not incarcerated, because that is key. And that is a focus of this court, and that will be a focus of this sentencing part. The community is at risk when you are out of being incarcerated, when you're not incarcerated, if you are not engaging in those services, if you are not going to your AA, if you are not going to your mental health therapy, if you are not taking your medications as prescribed, the community is at risk. OW8 could mean somebody has either been significantly injured or dead. Or you. And Mr. Canfield, you sound like a nice guy. And I'm seeing those tears. I usually have good tuition, and I can tell when they're fake. I think yours are real. And I don't think you're crying to the court because you are scared to go to prison. I bet you're scared to go to prison. I bet you don't want to go to prison. But I see these tears as actual remorse of actually understanding what you did, understanding what could have happened, and feeling terrible about it. With this case, I'm going to tell you, before I had heard the background information from the attorneys about you, I was definitely considering separate sentences consecutive to each other, and thinking that if I do that, then you have to sit your 3 years for your OWI, and with the other sentence, you would be able to engage in the substance abuse programs. You can still do that in prison, but you wouldn't get early release with your OWI. That was my way to try and ensure that you do engage in the substance abuse programs. But then again, hearing what you did while you were absconding, while you weren't here with your cases, it leads me to believe that if left alone and you are released and you have probation overseeing you, that you will continue to engage in that treatment. Because I don't think you like the person that you are sitting in orange, or at least the person that you were on August 28th, 2023. That is when the incident actually occurred, was in 2023. So with regards to this matter, the court is going to sentence you to 3 years of initial confinement, 3 years of extended supervision, and I am not making you eligible for challenge incarceration program or for the substance abuse programming, any early release while you're in your initial confinement stage. You could be eligible for that on the extended supervision if you are revoked. So that's something to pay attention to. I think that recommendation is a good recommendation. You'll have 3 years once you're released to do what you need to do and hopefully stay on that path and not self-medicate with the alcohol. The court is going to assess $6,002 in fines and fees and dean and surcharges, plus a $10 blood draw fee. You're going to need to make payments for that to be collected by the Department of Corrections while you are in prison at a percentage determined by the Department of Corrections to be reasonable. Absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia, AODA assessment, and follow through. Take your medications as prescribed. Continue with your mental health treatment as recommended. No bars, taverns, liquor stores, casinos, or any establishments that have the primary purpose for the sale or the service of alcohol. Regular alcohol testing. As it relates to the fleeing and eluding, the court is going to sentence you to 1.5 years of initial confinement and 2 years of extended supervision to be concurrent with the OWI sentence. The court is going to order that you provide your DNA. I do not believe that this is one that it can be expunged from the system, but you can check. If you fail to pay your fines and fees, not only will the court enter a civil judgment against you because you're always going to owe it, but the court will issue a warrant and you could sit up to 6 months in jail. This is a felony, no use or possession of a firearm for life, no voting in any election until your civil rights are restored. With the fleeing and eluding, again, I was contemplating a consecutive sentence because of the fleeing and eluding and the increasing speed, but this wasn't a high-speed chase. This wasn't where you were going 90 or 100 miles an hour. So could the public have been at risk? Yes, but it wasn't a substantial likelihood when you were not driving erratically and at a very high speed. You have 305 days of jail credit. That does not include today, correct?
That's right, Your Honor.
So 305 days of jail credit. I think that covers everything, Mr. Schmidt.
Nothing from me.
Mr. White.
Just making sure it was stated on record, we did agree to waive the PSI. I talked about that with Robert. We wanted to go right to sentencing today. The other issue that he brought up with me is, I don't know if it applies to a prison sentence or if it's just a county jail sentence that he has been an inmate worker in the county jail. I think he's been doing that for a couple months. Okay.
There's no good time for prison sentencing. That's why we're truth in sentencing.
Okay. I just wanted to bring it up. All right. I think that was it.
So you can understand that we're different than Minnesota. In Minnesota, you kind of get some good time or some things off of your sentences. In Wisconsin, you do not in prison. You do in jail, you do not in prison because we have what's called the Truth in Sentencing Act. And our sentences are truly the sentences unless you are able to engage in early release programming. In this particular sentence of initial confinement, you are not eligible because of the mandatory minimum. Okay?
Okay.
All right. So, and as it relates to the fleeing and eluding, the court is going to assess only $250 for the DNA surcharge. If that is all, then we are adjourned. Good luck, Mr. Canfield.
Thank you.
I hope you engage in programming while you're in custody in prison, even though it's not going to benefit you with early release.
I will.
And I do commend you again for engaging in the programming, even though you were.
Thank you.
All right. Thank you. We are adjourned. And I forgot to say this in my sentencing, but it really does touch my heart when I see people here supporting the defendants. We don't get family, we don't get friends supporting them enough. And even though you all knew he was going to go to prison, you're here and you're supporting him. And that means a lot to Mr. Canfield. And I'm going to tell you that means a lot to the court as well. So thank you for being here. Thank you, Mr. Canfield.
Love you guys. Thanks for coming.
Court will call the matters of the state of Michigan versus Matthew Taylor, 18-00188 and 18-343097.
Tiffany Woods for the people. Allison Muller here on behalf of Mr. Taylor. Mr. Taylor, can you state your name?
Taylor.
Thank you. All right, we're here today for 2 contempt hearings for failure to pay. Looks like based on what I have here in front of me, which is dated August the 22nd, Mr. Taylor has still failed to make any payments.
Yes, Your Honor, and we did leave a voicemail with Mr. Taylor, but did not speak with Mr. Taylor. I don't believe the financial hardship form has been submitted.
Well, do you want to speak with him before I make my ruling regarding contempt today?
I would, Your Honor. Thank you.
I don't.
You don't want to talk to an attorney, sir?
No, just going ahead with what you. Well, I understand what you had said last time. I was going to pay next month. I can start this coming month and start paying. I don't want to do the hardship form. And you could just be.
This is not just about a hardship form, sir. You're here for contempt today, which means that I can find you in contempt and sentence you to jail time today. Do you want to talk to an attorney? I can't hear you, sir.
I want to talk to them. I do not need them. Just going ahead with whatever you want to do with the contempt of court, please.
All right. Mr. Taylor has failed to make any payments in this particular matter. I do find him in contempt of court, and I sentence you to 10 days in a Washington County jail.
Can this be like suspended? Or, you know, so you get failure to pay. Wow. When I had surgery, it's like, what it, not making monthly payments. Wow.
So you made any payments on this case?
I mean, I had heart surgery, you know I did. I mean, I'm disabled. I mean, we already went over all this. It's sorry, it doesn't, I don't even care, honestly, so.
Yeah, it appears you don't care.
I said I could pay tomorrow, next month, so I mean, it's just money, but it doesn't matter to me. It's watch. No, I'll come in. Like I said, we should suspend it, honestly, until maybe, boy, you should give me like 3 months to do it. Maybe we could suspend it. We could double it or something. But, you know, like I said, I had heart surgery, so I'm still disabled. So, I mean, I don't know what, I can't get to the courthouse to do the things that you guys want me to do. So I can't get there to fill out no form. He sent me the form. I tried to fill it out on the Adobe thing. The signature won't go on there. So I tried to do it. I'm doing the best I can. I don't know. I tried to sign the paper. I couldn't sign it.
Mr. Taylor, please stop talking. I gave you a chance to speak with an attorney. You chose not to do that. I'm finding you in
That's fine.
contempt.
Just put out the warrant. It's fine. It's 10 days.
Well, in a minute, it's going to be more than that.
For money?
Mr. Taylor, I'd advise not to say anything.
It's not money. Now
You're not
you're
my
being.
attorney. You're really not my attorney. So you don't need to advise me on
If you
anything.
don't stop talking, I'm going to hold you in contempt and give you up to 90 days in a Washington County jail. Your 10 days are going to be held in abeyance, and I will give you until September 18th to make some payment on this case, Mr. Taylor. You can purge your contempt by making a payment.
What court is this with? Like, who do I make the payment? What court is this? A2 or A1?
It's neither. It's 14B District Court.
I don't even know what this is even for, to be honest with you. But okay, so I'm going to contact and try to pay for 14B. Just call up there, or?
Not your, you didn't need one. So call the court and they can give you whatever information you need. If a payment is not made, you can do 10 days and then you'll still owe the money.
Thank you.